Yes, you're most welcome to Bravo Podcast. Once again, it's a pleasure being here. I would like to appreciate everyone that shares our content. Please go ahead, share, like, or comment and give us what you view or what could be your view of our own podcast. Thank you. Today, we're going to speak about something very important. And in this case, it's a will. A will is a very important document or anything that can be left behind, most especially by somebody who has passed on. But in this case, we want to learn, is it important to make that will? And again, who makes the will? Is it the woman? Is it the man? Or both must make a will, or anyone, even when you're not married. In your cultures, how do they view the will? To some cultures, they are told that if somebody speaks about you making a will, it's as if they are calling death. And others will wait at the deathbed for them to make a will. If you're out there and watching this, have you made your will? Are you ready to make one? Or you did not know that a will is very important. Today we are joined with Fiona, a lawyer who has taken up that specialty as well on helping people make their wills or even understand the power, the importance, and the value that is in making a will. You're most welcome, Fiona, and it's a pleasure having you on my podcast. And I would like to appreciate you for taking time off your busy schedule to come and have information relayed out there to people.
Thank you so much, Bravo, for hosting me. I'm honored that you considered of all the other lawyers who could have spoken on the subject that you invited me. And the viewers, thank you for tuning in. I hope that by the end of this session, you will have learned a thing or two about wills.
Yes.
Yes.
Yes. Fiona, tell us about a will. Culturally, if you look at different regions, we have how we term will, a will. My first question to you is, should somebody make a will at that breeze point when they are leaving this earth?
All right. First of all, what is a will?
Yeah,
A will is a legal document
yeah,
wherein the testator is the person who makes a will.
yeah,
So every time you hear me say testator, just know it's the person who makes the will,
yeah,
expresses his desires that should happen upon death. And in this document, mostly people associate it with distribution of the estate, of the assets
yeah,
and possessions of the testator in question. So you may, some people culturally, different people have different ways of making quote unquote a will. Some other people, they go and confide in their friend. If I die, this is what should happen. They confide in their reverend, in their pastor, in their sibling, in their relative. But what we are going to discuss here is what in Uganda we consider within the framework of the law what the will is supposed to be.
yeah,
And the law we are talking about is the Succession Amendment Act of 2022. An amendment was done, and the legal regime around wills got new input, removed some things, introduced some things. Yeah, so basically that is what a will is. In
yeah,
case somebody else was wondering what is this will business they're talking about. In some other areas, they call it a testamentary document,
yeah,
but by and large, that is what the will is. What
yeah.
was the second part of the question that you asked me?
Yes, this the will. If we're talking about the will, is this a document made at the time when somebody is in their last days on earth?
Well, um, the advice that I would give is that don't wait until the last minute when you're extremely sick, you are in distress to make the will. Because under the framework of the law, a will can be contested.
Yeah,
And one of the grounds can be that you lacked capacity to make the will.
yeah,
And we're talking about somebody, for example, who is on their sick bed. What kind of mental framework are they in? Are
yeah,
they of sound mind?
Yeah.
So my advice would be, don't wait too long,
Yeah.
have the will, right? Because the eligibility to write a will is anybody who is of 18 years.
Yeah.
And since in the will, you're not only disposing of assets and possessions, but you're also making provisions like, if I die, who gets to be the guardian of my children in
Yeah.
case you have young children?
Yeah.
If I die, where will I be buried? Because in the country, in the past few years, we have seen people die, and two families, each one says, we are burying this person here, we are burying this person there. And people go to court to say, halt the whole funeral service until we can determine where we are going to have this person buried.
Yeah.
But if you have drafted your will, and in this will you have made it clear, this is where I want to be laid to rest,
Yeah.
then there is not going to be any contention. So I don't think that you should wait at the last minute on your deathbed to make a will.
Yeah.
No, but as soon as um, maybe you're 20, some people may think 20 is too young, but as long as you're 18, the law allows an 18-year-old to make a will. And since it's not really about property, you can make your will anytime. Maybe what you will have to know is that as you acquire property, as you begin to form a family, you either adopt or have your biological children, you can always go back and quote unquote update your will, or like revoke the old will and then you make new one depending on how the state of affairs, how the status quo has changed since the last time you had made that document.
Wow, you don't need to wait until when you're on a deathbed to make a will. In this case, in a family, married, in a family, husband and wife, in this case, who is responsible of making a will of the family?
Okay, there is no such thing as a will of the family, because a will is a personal document. These
Yeah.
are personal wishes. You
Yeah.
cannot say that, for me, I'm making a will, and in that will I'm saying, if my husband dies, you bury him here. No, you can only make a will in respect to yourself.
Yeah.
So and under the old law, I think because it was an old colonial law, they used to differentiate, and there was an undertone that only husbands could actually make the will, because at the time when that law was introduced in Uganda, in where we got that law from, women could not hold property.
Yeah.
So practically, they lived in the shadow of their husbands.
Yeah.
So all the laws which were made in that time and which we later got here tended to think that uh, a husband. So the wife was kind of out of the picture, because largely it would be the husband to decide her fate. But under the new law, there is equality of persons.
Yeah.
So spouses, both husband and wife, can make a will, because remember that this will is the wishes or the things you want to be implemented when you die.
Yeah.
So even if, for example, like I've said, you do not have property to give away in the will, you still have a sort of, where will I be buried?
Yeah.
Who gets to take care of my children?
Yeah.
Yeah. So look at it in that angle, that these are the wishes that should be implemented upon a person's demise.
Wow.
Yes.
Wow. And so you want to say that this new law really has empowered women as well to make their wills, because most women did not know that actually it's a very important aspect for a woman to make their will as well.
Yeah, I would say yes, but if we are talking about, I think that by and large, the whole legal regime under which we operate,
Yeah.
you know, empowers both sexes, men and
Amen.
women, husbands and wives. Because, for example, when you look at the rights of uh, parties contracting a marriage
Yeah.
in the Constitution, they say they have equal rights at the beginning, during, and at the dissolution of the marriage.
Yeah.
So whatever it is the man can do, the woman can
Can do.
also do.
Yeah.
So that will depend on the circumstances of the couple, but nothing out there stops women. Now, women cannot again use the law to say that the law is disadvantaging us, because
Yeah.
the law has come out to say that you have equal rights. You are allowed, you are given the platform to exercise this right as much as the other gender can exercise this right.
Wow. Let's talk about contradicting wills. I have a scenario where I've found out that there are three wills that have come in place at the death of someone. Okay, we found out that there were three wills talking about different things, and they are all appended to by the deceased. In this case, if they are contradicting wills, what happens?
Well, I am trying to figure out how they would be contradicting wills. Maybe let's just paint a picture.
Yeah,
You can make a will when you're 30,
yeah,
and the only thing you want to give away is your car, which you have.
yeah,
At 35, you acquire a house, you make a quote unquote will,
yeah,
where now in this new will, and in law we call it a codicil, this is like an addendum to the
mm,
other will.
yeah,
You can either revoke, because the wording in any will it always says this is the last will and testament.
yeah,
So in a way, it kind of says that whatever came before, I'm out of it. This is what I consider to be my very last will and testament
yeah,
of the person, whoever is making it. So it depends. If you find that the three contradicting wills are actually supplementary to one
yeah,
another,
yeah,
then they can all be considered.
yeah,
So in you made a will when you were 30, you had no children. You made a will when you're 35 and you have children. You have acquired property and you make another one when you're 40.
and yes,
When you're 40. So depending on the construction of those wills,
yeah,
they may all be held to be valid,
yeah,
because me, the person who makes the will, or one of the key requirements of the will is that you must appoint executors
yeah,
in the will.
yeah,
So if I appointed the same executors in those three parts of the same quote unquote same will,
yeah,
then there may not be an introduction.
yes,
But for example, if in one will I give away my house, but I have sold that house since I made that will,
yeah,
because the one thing you have to know about a will is that much as you're giving away, you're putting in place an instruction of how your estate is going to be divided. You're still allowed to deal with that property while you're alive, because
yes,
the will takes effect once you die.
yeah,
So where you find that there are extreme contradictions, then they may all be invalid or
yeah,
all nullified, and
yeah,
then now the estate of the deceased person will have to be divided under the rules of intestacy.
that's
Because when you have a will, we say you died tested, and when you don't have, we say you died intestate.
interesting.
Yes.
Wow, there's another scenario here where you find somebody has a will that is indicating 4 children, and then later on he acquired more 3 children when he had not actually amended or changed his will.
Mm,
How do you consider such a will that it was the last will he made,
mm.
but after that he had more other 3 children which were not who were not included in this will? How do you go about that?
Well, that would actually invalidate the will,
Yes.
because under the new law, there is a mandatory provision that you must provide for your lineal descendants.
Yeah.
They are not using the word children, like in the old law, where they would say illegitimate children or children born out of the wedlock. Now they are using a more blanket statement called lineal descendants. These are
Yes.
people who have descended from you.
Yeah.
So the law requires that you must provide for all these people. So it could be a ground to contest a will, that there are these children who were born after this will was made and they were not provided for. And because of that, we are contesting this will. Yes. It also applies to, for example, if you made a will and then you get divorced
Yeah.
and you marry again,
Yeah.
the subsequent marriage can invalidate that will, because spouses are expected to be provided for in the will.
Wow. I want us to take us back again on the divorce. Okay. You divorce when you had already made your will.
Yes.
After divorcing, you will remarry again
Yes.
another wife,
Yes.
and then later you pass on. Let's say you die before you changed your
Yes.
previous will.
Yes.
So, does the previous marriage claim that will, or it is the current marriage that actually claims that will, or it is invalid?
That is a ground for contesting that. It actually, a subsequent marriage invalidates a will. simple as that. If
Yeah.
you're married and you've made a will and you provided for a spouse in that will,
Yeah.
God forbid you either divorce or your spouse dies
Yeah.
and you remarry, you are expected to go back
And yeah,
and do something which reflects the current
the current
status.
status. Yes.
If you do not
Yes.
and present a will, for example, you say, oh, in this will, because in the will, you're expected to set your name, set your spouse or spouses, if you have more than one wife,
Mm.
uh, your children. So if we find that the person you stated as your wife, you have since divorced,
Yeah.
and we know that you married, that would be simple. That will be disregarded.
Mhm.
And once a will is, you can contest it in court. And I would think that if it's proven to court that there was a subsequent marriage, there had even been a divorce, there's a divorce decree absolute,
Yeah.
it is here, and uh, this man married another wife, here is a marriage certificate, the court would be inclined to invalidate that will.
Wow, that's amazing. I hope, guys, you're picking something out of our discussion. These are things you may be there watching, and you're like, maybe it's not doesn't concern me. I am single, or it doesn't concern me. I'm not married. It doesn't concern me. I'm still young. This is important information, and I believe you could go ahead and even share. I mean, share our video, like our video. Maybe you can also save it for future reference in case you need all this information that may be even costly for you when you go to consult a lawyer. In this case, a man is married to 4 wives, decides to make a will, and this will only takes up 1 wife. That when you read this will, it's actually a selfish will. How do we go about that as a family?
Well, like I said, it depends,
Yeah.
because there are people who may think are married when they are not.
Mm-hmm.
First, those marriages must be valid in the law.
Yeah.
And under our legal dispensation, if you do a customary marriage, you're allowed to marry as many wives.
Yeah.
So if they can actually prove that they are wives, they will have that will invalidated. Unless there is a reason you can't. Okay. In sometimes people will make a will and will not include the person who should be included, but they are giving a reason. For
Mm-hmm.
example, they will say, this is my last will and testament, my 8 plots I give to my one wife or my other 3 wives.
Mm-hmm.
Before I died, I had already given them their own portion.
Yes.
That's different.
Yes.
Because clearly the testator is saying, I'd already taken care of that business.
Yeah.
But if they have not,
Mm-hmm.
and these are your wives, they will go to court and they will contest that will, because you don't, these are your wives.
Yeah.
And the law expects that there is mandatory provision for you linear
Lineage.
descendants,
Yeah.
dependents, and spouses.
Yes.
Yes.
Wow, that's amazing. I have one family that there was a will. The father made a will. They had about 5 children, and the will was taking up the firstborn as the heir. But the rumor was in this family that this child did not belong to this man. After burial, later the will was read out, and he was given the role to take over by the will that was very clear, and it all went. But the families kept on, grudging until when they had to fight and say, he doesn't belong to us. The only option that was there was DNA. And now DNA proves that actually this child did not belong to this man. But this child grew up in the family of this man for all his entire life. In this case, how do you protect this child who is innocent? And how do you protect the family, or how do you bring back the family? While the will was clear that it should be the heir.
That is a question that has nothing to do with wills per se,
Yeah.
because you see, in the will,
Yeah.
I'm even at liberty to give the church, to give the hospital, to
Yes.
give my friend. They
Yes.
don't have to be my child.
Yes.
So for you to contest that will, I think it would have to depend on circumstances, because apart from your own children,
Yes.
you're allowed to give things to even other people.
Yes.
Now, if the person has already died, I think it would take the genius of the judge to
Yes.
look at the circumstances,
Yeah.
look at the evidence, and make that decision.
Yes.
Because we don't know what the person who died would have done had
Yeah.
he known this is not their child. They may have still,
Yeah.
loved them and,
Yeah.
given them this.
Yes.
So, but because they are not there, that that burden will fall onto court
Yes.
to now make a decision. And without speculating too much, it is a 50-50 kind of situation.
Yeah.
But if it is in the what is it in the intestate succession, definitely that child will be kicked out because it's saying linear descendants.
Mhm.
And when we count the people in this family, we are going to say that you don't belong. That's why, for me, I think it's very important for people to make the will, because in the will,
Yeah.
you put there what you want.
Now, he has made a will of what he wants,
Yes.
of a son or daughter in his home,
Mm.
a son who has grown in his home.
Yes.
He has brought him right from down. At the time of making a will, he made a will knowing this is my child. Definitely, the child has grown in his family. He doesn't know that actually, biologically, the
Mm.
child does not belong to him.
Yes.
And he made his will very clear.
Mm.
So, in this case, who contests the will and who has the power to break it? Because if you say that I have the powers to give to the church, to give to other individuals who are not related to me,
Yes.
if you are a judge today, as a lawyer,
Mm.
you are a judge,
Yes.
and this case is brought to you, what decision would you make over this son or daughter that grew up from this family?
Well, that is actually, I think that is the dilemma that the judges and the judicial officers
Yeah.
face, because you see, we have a person who in their sound mind made a will
Yes.
where you may be saying he didn't know.
Yes.
We don't know that he didn't know.
Probably he knew.
Probably he knew.
Yes.
But for you, you're saying, no, we don't want this person to take the portion that the testator gave them.
Yes.
I don't know. I would have to, examine the whole family to make that decision. Because let me tell you something. There are so many disputes to
Yeah.
do with succession.
Yeah.
I know cases where there are 10 children. A man had, say, two wives,
Yeah.
five. The five here say, you don't belong to our father.
Yeah.
The five say, you
You
don't
don't
belong
belong
to our father.
Yes.
And each one is saying, let us exhume the body and
And
we
do
do
DNA.
a direct DNA.
And the DNA comes, all of them do not belong to him.
And,
A lot of them don't belong to
they
him.
don't
Yeah.
belong to him.
Yes.
But there is also it's a new concept in the law,
Yes.
something called the kinship test, where they are testing to see, are you people actually related?
Yes.
But most people are disputing it as what if we are related, because maybe
My brother
yeah, my brother.
slept with my wife.
So that would be a huge dilemma.
Yeah.
I don't know how I would decide that case, because by the time, there are people who don't have biological children, but they refer to whoever it is that they have raised as their child.
Yeah.
So they will say, this is my child. And by the way, what you need to know is that under the new law,
Yeah.
adopted children are considered children.
Yeah. Because yes, in reality,
Yes.
if I adopt
so
a child,
so if I'm the lawyer, I would take the angle that if adopted children are expected to be considered children,
yeah,
we don't know whether this man knew or didn't know.
yeah,
It would be unfair for us to put away his wishes, because remember, the will is about implementing the wishes of the deceased
yeah,
on the mere DNA result.
yeah,
Maybe he knew, maybe he didn't know, but now we can't ask him.
yeah,
So probably you would have to either maintain the will as it is. The only problem is that, when property is involved, people live with one another,
yeah,
animosity, hostilities, all those things. But by and large, that would be a huge dilemma. A huge dilemma.
yeah,
But without speculating what the judge would do, if I'm the lawyer who is arguing that matter,
hmm
I would just simply say, these are the wishes of the deceased.
Yes.
This
We'll
man
go
could
for
have
it.
given the property to the church, and the church would not have to prove DNA.
Yes.
He could have given property to his best friend, and they
Yeah.
would not have
Proven
proved
DNA.
DNA.
Yeah.
He could have given the property to his youngest sibling, whom he raised, and he considers him a son instead of a brother.
Yes.
So, it you would have to come up with technicalities on how to navigate that kind of situation.
Yeah.
Yes.
That's amazing. I hope, guys, you're learning. And these are things we're talking about that are in our communities. These are things that are out in your neighborhood. In Uganda, they're so popular and so common. And I'm here to give you this knowledge. Guys, keep on, listen, but please do us a favor and share this content. Once again, we would like to appreciate Naria Motel, where we do our podcast from. We appreciate this place. And please take time and visit this place whenever you're free. So now, can a man make a will and let the wife be the custodian of his will? I may be there, I don't have anybody I trust, but I trust my wife. And I've made my will, and I want my wife, because I trust her, believe in her, to make sure that she's the custodian of my will. That even when I'm making a will, my wife is aware of what I've put in the will, and she becomes the custodian of this will.
Okay, so this is an action-packed question. So we need to actually know
Yes.
what the law requires to be done when it comes to drafting a will.
Yes.
First of all, under the new law, the will must be in writing.
Yes.
There has always been a notion in the subject of wills that it, the testator, when they make their will, that will must be attested to or
Yeah.
must be witnessed.
Yeah.
The witnesses can never be beneficiaries in the will.
Yeah.
So if you get your wife to witness
Uh-huh.
and she's supposed to be a beneficiary,
Yes.
that's a ground for invalidating the will.
Yeah.
Your children should not attest to
Yeah.
the will. But even the people who attest or witness the will, they never read the content.
Yes.
They don't.
Yeah.
Because probably they would go and say, hey, by the way, do you know if your father dies, you're going to get that house and your brother will only get 2 goats?
Yes.
So to avoid all that, the process how the will is made is that a will is a secret by and large.
Yeah.
It should only be opened at the time of reading it and trying to implement it.
Yeah.
But let's assume you come to me.
Yeah.
You tell me if you're not draft for me a will. Once I draft it, you know what you've told me.
Yeah.
I know what you've told me.
Yeah.
Now you bring 3 people who are going to
Witness.
witness, but we call it attesting.
Yeah.
The new law requires that they write their name on each and every page of the will. As they write, we cover the contents.
They shouldn't see the content.
They should not see the
And
contents.
yet they are the ones who are going to keep copies.
Yes. Well, because you see how they are trusting that once they put it in the envelope, they seal it.
Yes.
Your job is to keep it in the safe. You only open it when that man has died.
I can open I can open the envelope and seal it again.
No.
Yeah. I can open the envelope and seal again the same envelope.
You see,
Yes.
that is because you're not a trustworthy person.
Yes.
But people who are keeping other people's wills, they
No, I may be trusted, but I want to say yes,
No,
and I will say it. But and I think so many things have happened.
Bravo, I'm not giving you my will to keep.
Yes.
I'm not giving you my will to keep. So
Yes.
what I was saying is this. So the reason why you find people prefer to at least have 3 people who attest to the will,
Yeah.
and each will be handed a sealed envelope
Yes.
on the day of reading the will, or maybe one lawyer will keep it, or they'll keep it at the bank.
Yeah.
If you, myself, and another person bring so and so's will, and we open it, should have the same content.
Yes.
Now, for you, if whether you go and you remove the seal because of curiosity, that is your business. But
Yeah.
that is something you shouldn't do, because your job is that when the maker of the will or the testator made the will, when they signed, I was there.
Yes.
I witnessed for them and they were there.
Yes.
The job of the lawyer comes back,
Yeah.
because you have got to petition court,
Yeah.
attach that will, attach the relevant documents, and apply for what we call probate,
Yeah.
because it is the probate that you get that allows you to implement the will.
Yeah.
If there is a car which you've left to your daughter, they need that will and probate to transfer it first to themselves
Yeah.
and then to the person who is the beneficiary.
Yeah.
If it is the land title, they have to remove the person, put the executors,
Yeah.
and then these people transfer to the respective beneficiary.
Yeah.
So don't try to get your own children to witness the will,
Yes.
because people will say, but how sure are we you did not influence?
Yeah.
How come you're the one who witnessed and you're the one who got the plot in Kololo? And for us, we got the plot in Busega.
There are these scenarios. There are these scenarios. I have a family. I'm sorry. I think I'll not mention the name. I have a family friend who made his will very clearly, and he calls his friends. So among the friends he called was actually a boyfriend of the wife. So he made the will, sealed his will, and distributed it to his friends. And this friend happened to tell the wife that actually your husband has given me the will. So what they did, they opened the will, they went, opened the will. Like as I've told, I was asking you that can't people open the will and seal it again? So what happens is that they went, opened this will with this man. So whatever had been indicated in this will, and guess what? The woman accepted, she behaved until later when they had an argument and quarrels came into the home, and she revealed the secret that she knew whatever was in the will. And in this case, see what happened in the family. So the whole family went into, but of course, the disappointment and betrayal. So in this case, how do you advise somebody making a will? Should they entrust a stranger with this will? Or what categories of people should be the custodian of our wills?
Well, what I know is people keep their wills with their lawyers,
Yeah,
because for us in our profession, we have what we call client confidentiality.
yeah,
Whatever it is that you disclose to me,
yeah,
the professional conduct binds me not from disclosing that information to another person.
yeah,
It depends on the kind of relations that you have. There are people who trust their bishop, there are people who trust their pastor,
mm-hmm,
there are people who trust their brother, there are people who trust their grandmother, they have a best friend. But all I can say is that it is better you have at least your will in three different places.
yeah,
Mm. You have the will, the people who have safe boxes with the bank
yeah,
and other areas where they can keep things. So you can choose. There is no like I've told you. I know there's a lady. She's a client of mine. She's elderly. She told me she's been keeping her friend's will for 25 years.
yeah.
And what came to my mind was, hasn't there been a day of curiosity so that she
Kind of.
Yeah, but that is what is expected.
Yeah,
Remember that most of those people who are keeping these wills are not beneficiaries
they're not
in those
beneficial.
wills.
Yeah,
The people who are going to execute most times, they are not beneficiaries,
okay.
because that is what they are trying to avoid. Because once you know there is a benefit for me, you may even have motive to kill this man, because the will is only functional upon the death of the person. As long as they are living,
Mm-hmm. They can change it.
they can change it. You have no access to it, Yeah.
Wow. This is amazing. I hope we are able to learn something as well in this discussion. And have you prepared your own will? It doesn't mean that you're dying tomorrow. Let the lawyer tell us. Is making a will about to die? Or is somebody making a will about to die? Or should people consider when they have, let's say, terminal illness, non-communicable diseases, or somebody at advanced age, is it the time for me to make the will? Oh, as you said, yes, at 18 I can make a will. Must you be rich to make a will anyway?
Well, I think that this goes back to the very first question we asked. And maybe to answer this question, what kind of information um, there's a video I previously made about the 9 key features of a will, or the
Mhm.
9 key things that you should include in the will. Um, some of them are to do with appointing a guardian for your minor children,
Yeah.
choosing a place where you want to be buried. And incidentally, when we talk about possessions, people think car, land, title. Your clothes are your possessions.
Yeah.
You choose who gets to get your clothes when you die.
Yeah.
Who is going to take your bed when you die?
Yeah.
So those are some of the things that people have. Where does your phone go? Who gets to inherit your iPhone 16 Pro Max? so so it's just that people, the reason why young people will find it difficult to make a will is they don't think they're about to die.
Yeah.
Now the older people think, if I am already old, if I make the will, death will kill me faster.
Yes.
So because of all those things, I think people find that they are restrained from making wills. But for me, what I would advise, especially if you have reached the age of 30,
Make a will.
make a will. Make a will, make a proper will. And every other 2 years, if you have an opportunity, you made a will when you didn't have a car, now you have a car. But also, by and large, the will helps you to take stock of your estate.
Yeah.
You have money in this circle, you have money in the other chibin,
Yeah.
you have money in NSSF, you have money at your previous work where there was a gratuity kind of
Yeah.
scheme. You have shares, you have land, you have NSSF.
Yeah.
Maybe there is another village circle your parents forced you into and you bought their 2,000 shares. So, one of the key features of the will is that you list everything you own
Yeah.
and where it is,
Yes.
and then you distribute it. But there are people who, when you sit with them,
Yeah.
they say, but me now, what do I have? I don't have anything.
Yeah.
You're like, don't you have that insurance policy? Yeah,
Yes.
by the way, I have it. What about the other circle? There, I have there like 6 million.
Yeah.
What about maybe that OB thing of yours? Yeah, even there, I have there 3.
Yeah.
Before they know it, once they add, they have some 40 million lying somewhere. And if they die and there's nobody who knows where these things are,
Yeah.
those things are going to be lost.
Yeah.
So part of what can part of the encouragement for you, even if it's a draft of the will,
Yeah.
it helps you to take stock
Yeah.
of your thing, of your estate. But also it allows you to give away your things as you wish. Because if you don't have, I can give to the church, I can give to the orphanage, I
Yeah.
can give to my best friend, I can give to my housemate
Yeah.
who has served me well, who helped me raise my children.
Yeah.
I can appoint somebody to, um, take care of my children when I'm not there.
Yeah.
I can make a provision for all these rental houses I have, let all the income through these years, educate my children, and once they are fully educated, then this is what should then happen. You
Yeah.
do that. But when that's not in place and we go to succession in intestacy where there's no will, the law is strict on who benefits and what percent.
Yeah.
No, because under that law, lineal descendants are supposed to take 75%.
Yeah. The
The
wife.
dependents 4%, the spouse 20%, the customary heir 1%. So you see that if you are to adhere strictly to those percentages, the spouse will always lose.
Yeah.
They
Yeah.
will lose because
Yeah.
they're only getting 20%. And
Yeah.
since they are considering lineal descendants, let's paint a scenario. You were married.
Yeah.
Let's say you only had 3 kids. Your children got married and they have kids. Now you are 80 years and your wife is like 75.
Yeah.
Your 3 children died, but you have grandchildren.
Yeah.
Now, if one of them dies, let's assume the man is the one who had money,
Yeah.
and women don't come for me on this. The wife takes 20% and the grandchildren take 75.
Mhm.
Do you see how unfair it
Very
would
unfair.
be?
Yeah.
How unfair would be if you go to apply those rules. But where you
You have
have a
a will.
will,
I can give my spouse 100%.
you can give your spouse 100%,
Yeah.
or for whatever reasons, because we are also assuming probably there are other people who depend on you.
Yeah.
So the will not only helps you to streamline your estate, but to minimize the chaos.
The chaos.
The chaos,
Because the law would be rough.
the law is
Mm,
going to be rough.
yeah.
But also, um, a key thing under the new succession dispensation is that you cannot give away a principal home in a will
Yeah.
to another person apart from the spouse if
Yeah.
you've not provided another home of equal standing.
Okay.
That means, because you remember that once the will is read and they have said,
And this
bravo,
is
you're
the order
taking
of
the
the
zero
elder.
track.
You're
You're,
going,
ta-
you drive it away.
you're taking
Oh,
the
this
zero
house
track.
belongs to you.
You
You
drive
say, get out,
get
everybody,
out.
get out. Yeah.
This is my house. I
Yeah.
want to sell it.
We've seen many of them.
Aha.
We've
Now
seen
they are
many of
trying
them.
to protect a surviving spouse
Yeah.
from being evicted. And
Yeah.
let me tell you, you may think you love your mother or father or your brothers are good, you've been happy on Christmas until
Until the
they
death.
die
Actually,
and there's money in the
yeah.
eviction. So you say,
Is this my sister? Is this my brother? Yes.
bravo, I've always suspected you not to be my father's child.
Yes.
And
Yeah.
things begin
Of
going
course.
south.
Of course.
So for you
Yeah.
to, I'm not saying that when you have the will, they will not be there, but at least you're trying to mitigate the risk of it happening.
Yes.
Yeah.
Wow. In this case, let's look at this scenario. I am a husband. I have a wife. I choose not to make a will, but I leave a simple will. And this will says that everything is willed in the names of my wife, the mother of my children.
Mm-hmm.
And I am giving instruction that the mother of my children, at her time of death, should be the one to make our last will as a family, to dispute whatever she will have. But at the moment, as she's still alive, everything belongs to her because I worked for this property with my wife, and she has equal rights as the surviving parent. So in her last days, she could hope and make a will that will set our family off the ground. Is this acceptable under the law? Can I make it as a man? Because when I tell you this, there are husbands out there whose them and their wives are close like this. And the husband feels doesn't want to disappoint the wife and wants to be fair enough and say, my wife, where I'm not, you're a decision maker. Where I am a decision maker. At the time of my death, I don't want you to suffer. I want you to remain in control. But do me a favor. That even before we do that, maybe I have negotiated or not negotiated. I have discussed with my wife on the distribution that is clear. And I've told her that if you're to die, please make a will and distribute this to our children equally, me as I leave this world. Can this will be honored or respected?
All right. Thank you so much for the question that you asked. I think it's very, very important to actually consult and involve a lawyer before you draft what you may think is a simple will.
Yeah.
Because you see, the will is implemented after you die.
Yeah.
And unless, in the scenario that you gave, unless, for example, you're saying that I have rental property, and that rental property, during the lifetime of my wife, she's allowed to use the income, and upon death, that property will go to my children.
Yes.
That one is would be an acceptable term in the will.
Upon
But
her
where
death.
yeah, but upon where you say that upon her own death, now she will make another will where she leaves it to the children.
Yes.
No, that will not work. Because you see, you are already dead.
Yeah.
Where you have willed the property to her, you have given the thing to her.
Yes.
You remember that once you receive something in the will, you can sell it.
Yes.
But where, for example, you say, during the lifetime of my wife, she's allowed to use that property for all the income that comes from there is supposed to go
To
to
her.
to her or to educate my children.
Yeah.
There, and once probably they finish their education, this property will now go into their name. Because what you're trying to avoid here
Yeah.
is make a will where there is nobody to supervise to implement.
My wife can implement.
Yes, but you see who is supervising her to make sure that she's.
But there's nobody supervising me. So in this case,
I,
don't you think the law or society is still considering women,
mm,
mm-hmm. still considering women as lesser? Because if you say that nobody's supervising her, she's not a child.
Well,
because in this scenario, there's nobody supervising me as a man.
Wait.
As a man, the boss, the owner of this property, I have willed everything to my wife. And I have given even powers to my wife, no matter whatever she will do, that at time of going, she will be free to dispute, even through my guidance. Maybe we have agreed in advance that when you are to die, please kindly make this will, give this, so and so. But I will not include it in the will. That even if my wife chooses something different, I am okay with it and I die. Why do you think that my wife needs supervision? Are women still considered not able by themselves?
That question is not about women.
Yes.
That question is about the ability to implement the will. It could be the woman making the will and it is the man on the other side.
Which
let's flip it, because I don't want people to take this conversation as a conversation or an attack to say women are lesser or women are not trustworthy.
Yes.
Okay, let's just paint another example. Let's assume you have children, your wife died,
yes,
and you have a sister whom you trust to raise these children in case you're not there.
Yes.
So in the will, we will say, I leave everything to my sister to take care of, and if she is to die, she should now leave everything to my children. It is still the same scenario.
Yes.
Or even if it's a brother or an uncle or an auntie.
Yeah.
What I'm trying to say is that depending on the language used, you cannot say that upon your own death, you will those things now to the children.
Yes.
I'm saying if you have procured services of a lawyer, they may advise you that the best way to have this will implemented is to say, I have died, and maybe I'm appointing my wife as the guardian of the children, and also this property, which is a property she can use to take care of the children during her lifetime, using that income to take care of the children's education, health, and what. And upon her demise, the property will go to the children. You see, you're not leaving the clause open to her to make a new will and pass on the property. You're simply actually going past one individual and taking care of the next individual. You're saying, my brother is the guardian of my children.
Yes.
He shall be charged with collecting rent, renovating this house, and making sure that the income from this house will take care of my minor children for the next 10, 15 years, depending on how old your children are. And then you're saying, upon my children maybe attaining the age of 23,
they will take over.
They will take over.
Yes.
That one, because you see, the other one of saying, upon her own demise, she will write her own will, where now she will give now the property to the children.
Yes.
It becomes hard to, quote unquote, even have court implement that. Because
let's look at this. This is the mother. I'm trying to look at where fairness is.
Use the man. This is the woman who had the property. This is the father. Because people, I don't want them to misunderstand this.
Okay, this is the mother of the children, isn't it?
Yes.
As a couple, we have agreed. We are very honest to each other. And I don't want confusion. I know you may never choose to eat things out from your children, because these are your children. I mean, even men have taken things away from their children. It's all humanity. But I'm here agreeing to my wife and say, we made this property together. And then, to me, not to have any confusion, once you die as a woman, everything goes back to me as a man. I'm still the controller. If I die as a man and you're alive, you will definitely take over everything as a wife, because these are our children. Leave alone where there are other children. But these are, let's say we have 4 children. And this mother takes full responsibility of this property. And I give a chance. I give the rights to the mother to will. Maybe we could even discuss it, like as I've said. We discuss it, me and you, and say, okay, what we will do, there are 4 children. By the time you die, they're all alive, 25, 25, 25%.
Mm.
They all take their things. And we agree and we have accepted. And I go, what's wrong with that? Because if I have democracy in my family, I have implemented something. Why do you force me to say that no, don't allow this woman to do this? Let me ask you this again. Is it because you think that women can remarry again? And is a woman remarrying stopping her from assuming full responsibility of her former husband's property when he died?
Okay,
Yes.
so let's go back in the law, because
Yeah.
we can use our own opinion to
Yes.
discuss,
Yes.
or we can go and say, what does the law say?
Yes.
The law has said one of the grounds for contestation of a will is if you have not provided or complied with what the law requires.
Yes.
And I told you that right now they are looking at 3 categories of people:
Yeah.
spouses, lineal descendants, where the children fall, and the dependents.
Yeah.
So now in this will, you've only provided for your spouse per se. I would think that um, for you to look like you also provided for the children,
Yeah.
because what people, let me tell you, the language people who use in the will is that I have my 18-year-old,
Yeah.
my 8-year-old, okay, let's say my
Yeah.
daughter is 4 years.
Yeah.
I have my 4-year-old daughter. Maybe at the time when you die, she's 6 years old.
Yeah.
This house, Nadia Motel, I will it to her.
Yeah.
But I am appointing my wife as the guardian to
Yeah.
care for that property until she's of age
Yes. And she
to
takes
be
over.
able to take over.
Yes.
But in your scenario, you're not leaving anything to your children. You're leaving everything to your wife.
Yeah, because that's
Hold
the
on,
mother.
hold on. It is the mother. Nobody is contesting that.
Yes.
But remember, the law expects you to distribute to 3 categories of people:
Yeah.
spouse, lineal descendants, who are the children,
Yes.
and dependents. For example, you may be living with your mom or your sibling.
Yeah.
These are people who depend on you.
Yeah.
Now, of those 3 categories, you choose one.
Yeah.
Tell me why somebody will not contest that will. And this has nothing to do with capacity, remarriage, honesty,
Yeah.
or evilness. It
Yeah.
is simply a non-compliant document. That's what I'm saying. This has nothing to do with whether, because I know also women who say, how can I leave my land to the husband? If I die, he will remarry.
Yes.
It is already like you're dead. Get
Yes.
over yourself.
Yeah, you're really
You may
dead.
be dead. But what I'm trying to say, this has nothing to do, because your wishes must be compliant in the law.
In the law.
In
So
the
you
law.
can't. Wow. So
Because the other thing is that, remember that once I receive my portion in the will,
yes.
I can sell.
Yes. You
I'm
have
not going to say your wife will not sell. She may get a problem and she may
which
sell.
is okay, which
Eh?
I'm very comfortable with.
Yes.
Yes.
But in my own scenario, where I'm saying, if she's appointed as a trustee, holding that property in trust of the children,
Yes.
she cannot do anything to prejudice their interests.
Yeah.
You understand? So this discussion or this scenario has nothing to do with whether women are weak, whether women are good, whether women are bad.
It is
It
the law.
is just you trying to comply with the law. And
Yeah.
if you want to take that route, there are other ways. There is something, maybe another time we can come and discuss something called a trust. A trust is also an estate planning tool,
Yeah.
and for it comes into effect before you die.
That's right.
You know, a trust. So for it, instead of we wait for a person to die and then we begin distributing the property, if I put a trust in place, it begins working.
Yeah.
So we can always have another discussion around it, because it is
Trust,
also
yeah.
matters. The
Wider.
will is an estate planning tool. Also, the trust is an estate planning tool. All I'm saying is that depending on how you have drafted the clause,
Yes.
it will make it compliant or non-compliant. If in that clause it feels like you've not actually provided for your children, somebody can contest.
Yeah.
Somebody can contest.
Yeah.
But if you're saying that I have minors, even if I'm to give them the house, even if I'm to will them the business, they are not able to care for it, my wife is the guardian in that respect
Yeah.
for the good of the children.
Yes.
That would be a good
Wow.
clause.
So I think we've learned on how to make that will as a husband. You love your wife and you'd want your wife really to assume full powers. What I've understood from this is I can appoint her as a full guardian, and I would even stretch it on certain years until when for example, she's 50 years, you can say, oh, the guardian of my children until 75, maybe 80.
No, actually, the time
Yeah,
should be on the young person.
on the young
You're
person.
like your 8 years, between the ages of 8 and 25.
Yes,
Your parents should still be in charge.
yes,
And once you clock 25
yes.
and maybe you finish your education, you can put conditions, because I think in the Western world they put conditions like after you attain
Yeah,
your two
certain time.
degrees,
Yes,
or if you turn 25, then they can be able to trust you with now this asset, because uh, there is this whole debate of rich people, when they die, their children have not built capacity to care for this.
mhm,
In 2 3 years, businesses have collapsed, the
yeah,
estate has disintegrated, they have sold off everything. So part of the reason why sometimes they say at the age of 25 or age of 23, or after you finish your studies, is to also allow this child to grow, to be in a position of assuming responsibility for this asset or whatever it is they're receiving in the will, to take care of it. But in the meantime, your father or your mother or your sister or your uncle is the guardian, and their responsibilities are to use that property for your benefit, not for any other thing, for either selfish gain or something.
wow. Thank you so much, guys. It's a pleasure having Fiona here, a senior lawyer, person who is very passionate. Some of these topics depends on how passionate this person is. You are able to get information from us. Fiona is available. You can look for her, and she can be able to guide you through this process. Before you think about making a will, think twice. There are wishes that are really important, but are they aligned to the law? You may say, I wish to be buried at City House or at City Square. And then this will
Or
not be on.
cremated.
Or no, cremation. Of course, I love cremation, by the way. And
Mm.
myself, I'm a person of cremation, and I've always told people I need to put it in writing. But
Yeah,
I
Kama
like
will
to
do
be
that with.
cremated. This is my will. You're here, we're a lawyer.
One of the mandatory requirements that
It's-
it should be in writing,
it should be in writing,
and
but
there
even
should
in
be
camera. But
people who must attest
no,
to it.
listen. But even in camera here, I've said I love to be cremated, and I've put it in camera. So, and I'm
I
with you
love
with a
to be
lawyer.
is I shall,
I
is
shall.
not I
I
shall,
love to be.
because
Oh, I shall be cremated. So you see the terms now here. We need to understand it. You need to understand the language that I shall be
is
cremated.
mandatory, but also you must appoint an executor to put in place that which you wish
You are the
to
lawyer
happen.
now. We've made it here. So my will is I shall be cremated, and in front of the lawyer, she'll bring out the camera because that's part of the evidence. At the end of the day, I've not been coerced, or I've not been personally. So thank you so much, guys. Let's get information. Let's improve ourselves. Let's know what it involves, guys. It's simple. And our cultures, sometimes our cultures derail us. They think that yes, death is knocking on the door, but I think it's not. And we must appreciate, of course, internet, that all information is now available. Even whenever you are countryside, across the country, the other side of the information is available. One last thing that I would want that I'd forgotten. Somebody's in the diaspora, somebody's in the USA, somebody's in Canada, somebody's in the UK. They've taken so many years without coming back to Uganda. They feel they're aging because there are reasons why they cannot come back to this country. But they want to put up a will where the children are here and the family is here, but they are not physically in the country, and they want to know how to go about this. In this case, what do you advise this person?
Well, they can make the will from whichever country they are at.
Yeah,
I would advise them to follow what our own law says.
the laws here.
Yes,
Yes,
they do their will wherever, whichever country they have, because at the end of the day, we have seen wills which were not made while people are in Uganda.
yeah,
We have seen For example, maybe something related. You may find they have property which is in the US.
Yes.
Eh? People have properties across the globe.
Yes.
So I don't want people to think that you have to be in the country where the property is to make the will in respect of that property.
Yeah.
No, there are just other guidelines that may come up. For example, once you get that probate, what else must you do to it for it to have the force of law in another country?
Yes.
So you being in the US, you being in Kenya, being in Tanzania cannot stop you from
Making a will.
making a
But you
will.
must be aware of the law. What
You
the law
need,
says,
yes.
where that will be applicable. Is that so?
Well, yes, I want to say that because there are other countries where somebody will write something on a piece of paper and it will be allowed.
Yeah.
Our law has said it shall be in writing. It should include this. It should include the other. You must write your name on each and every page of the will. Your testators must write their names and I think their contacts or residences on each and every page. So you want to be in compliance with what the law says, because otherwise people will say, "Oh, okay, maybe this is not good enough. You're saying we are on camera. This is my will.
Yes.
The law has said it shall be in writing." So you will take this video to court and the judge will say, what does the law allow electronic wills?
Yeah, at the moment, yeah.
At the moment, if they say no, then it will fall through the crack.
Yeah, and you will not blame the judge because he followed the law.
Yes.
Yes. Oh, that's and so many people have lost money. So many people have had money that they have not declared, and they are dead, and the families are struggling when the man had a lot of money somewhere and not even.
Yeah, the thing which I talked about, that the will help you take stock, but
Of
also
whatever.
even if you don't have the will, there are some 5 people where all your money is.
But these
such
days
that
we don't
know.
trust people. There are few people who are trusted these days. Betrayal is at the corner all
I
the
don't
time.
know.
Yes. So thank you so much, guys. It's a pleasure. Once again, we'll bring her again one time to talk about the
Trusts.
the trusts. I know so many people in the US have always told about the trust. My estate is in the trust. When I get a problem, I am protected. Is it?
Yeah.
I am protected because things are run by the trust, not by me. So there's nothing that and I found it very interesting when somebody told me about the trust.
Yes.
But are they applicable in Uganda?
Yes. We have a law on trust and people have them.
Wonderful, guys. We're going to understand what trusts are. There's so much here, guys. Let's not remain in ignorance, and let's not even leave our families in ignorance. And this has nothing to do whether you went to school or not. It's about getting information. Once you land on the information, you're a land friend like my friend here. So thank you so much. It's a pleasure once again. And we would like you to have a closing remark in 1 minute as we see our viewers off.
Dear viewers, thank you so much for staying this long. Thank you for giving us your time, for subscribing to Bravo Podcasts, for, taking the time to learn these things, for contending for knowledge. It is a very, very good thing for people to acquire knowledge, but also to go beyond knowledge and apply it. Now, having known that you can make a will, my happiness or my joy would be for somebody to say, because I watched the Bravo podcast where they discuss the importance of the will, I was able to take stock of my estate and I have put a will in place. And this knowledge is not just going over your head, for lack of a better word. I thank you so much for your time, for your patience. Thank you for the people who are going to share. We will see you. I encourage you to go tune in and watch all the episodes that Bravo has made available to you. Like he said, this is about knowledge. Knowledge acquisition and application of knowledge is the only way we have to go in this world. And we cannot say, for people who are in an information age, you can access this at the click of your finger. And once you access it, share it with somebody else, because there is no reason why only you should have this knowledge. Share it. That is the only way we shall all be helped. Thank you.
Thank you so much. Please give them your number if you're comfortable. You can give your email. Somebody can write to you as a lawyer, and somebody can also
they will write it at the base. They will write it at the base. Yes. I will give it, and they will write it at the base. You can contact me.
Yeah.
Like I said, they will put my full name, so they can contact me.
Yes. Wonderful. Thank you so much, guys. It's once again a pleasure being here. Please share our content as we spread the gospel. We spread the information that people need out there. Thank you and have a great day.